Hi, everybody. I'm going to get started here in just about a minute. So I did bring paper, hard copies of the presentations in a box back there. If they happen to run out, you can email me, and I will be happy to email you a copy when the presentation is over. It's kind of good news in one way and bad news in another. I'm sorry for those of you who didn't get one. I believe we will be posting the presentations online. Yes, we will. But also, if you email me, I will email you an electronic copy as well. My email is D as in Donald, my first name, Young, Y-O-U-N-G, at boylancode.com, just like on this slide here, boylancode.com. So I guess I've already started to introduce myself then. So I'm Donald Young. I'm with a law firm in the Rochester, New York area. I practice in the land use and municipal field. I represent a number of small to mid-sized municipalities. I also do a little bit of work on the other side of the table for developers. It gives me a bit of a unique perspective, I think, in looking at some of this stuff. I spend a significant amount of my time dealing with SEQR, and so I hope to share some interesting tidbits with you today. This will be a SEQR update. We'll look at a few recent cases, and we'll also look at the recent regulatory changes that just went into effect this year. So, curious, how many of you would consider yourself to be very comfortable and familiar with SEQR by raise of hand? All right, and how about the other way? Not terribly comfortable, not terribly familiar, raise of hands. Okay, a good mix. So I am going to give just a brief overview of some SEQR 101 stuff, I guess. Hopefully there's some tidbits you can all pick up, even if you are familiar with SEQR. But I'll be quick with it. Oh, yeah. Okay. So SEQR is the New York State regulations, more formally known as the State Environmental Quality Review Act. Some people do SEQR, some people do SEQRA. I don't know why. One picks one over the other. It requires governmental agencies to balance the potential adverse environmental impacts of inaction against its social and economic benefits. That's the basic definition of what SEQR is. It's an environmental review of basically a proposal before a municipal board usually. So this graphic here on the right side of the screen is, I believe it's from the SEQR handbook. And I think it's a really neat flow chart to look at when we're thinking about how SEQR starts and how you get to the end. And so basically we're just going to look at look at this very quickly to get our bearings before we dig into some of the updates on the regulations and some of the case law, so we're on the same page. So the first step up at the top of that flow chart is classifying the action. We want to think about whether SEQR applies at all in the first place. So SEQR applies basically in three instances. When there's an action directly undertaken by an agency, so typically in our world an agency would be a municipality like a town or a village or a county or a city. Maybe that would be building something or acquiring land or dedicating land, things like that. Funding something is the next one, funding by an agency, so purchasing something or maybe a grant from the DEC, things like that. And the third way it may apply is requiring discretionary approval by an agency. This is the most common one that I deal with and probably most of you. So site plan approval, variances, subdivision approval, rezones. Most approvals you give at the local municipal board level are subject to SEQR. Okay, so if it does apply, if we check off the box on this first step here, the next box in the next line on the flow chart shows you how you classify the action. So we have to classify it into one of the three buckets. Either it's a type 1 action, it's an unlisted action, or it's a type 2 action. Now, the SEQR regulations have a list for type 1, and they have a list for type 2, but they don't have any list for unlisted, which makes sense because it's called unlisted. So anything that's not a type 1 or type 2 list is an unlisted action. The type 1 list are actions that are most likely to have a significant adverse environmental impact. So they're typically the bigger, more substantial actions. You'll see some examples on the slide here. Zoning changes that are more than 25 acres, the construction of at least 200 residential units, an industrial project greater than 10 acres. Those would all be examples of type 1 actions, and there's many more in the SEQR regulations on the type 1 list. Unlisted action is the middle ground, maybe not so substantial as a type 1, but more substantial than a type 2 action. So those might be things like industrial projects that are 5 acres, zoning changes for 10 acres, etc. And then type 2 actions. So these are very minor actions that if they fall into the type 2 list, they're not subject to SEQR at all. You're done. If you classify it as a type 2 action, you're done with your environmental review for New York law. Repair of a building, construction of a single family home, setback variances, conducting studies, purchase of equipment, those are all actions, but they're type 2, so they're not subject to further SEQR review. All right. So then we get on to the next line here. We've classified the action, and now we're gonna start our actual substantive review. This review, New York has made it. I don't want to say easy, but they've made it somewhat automated, the review, by giving us the environmental assessment form. It's a great form, and a lot of times municipal board members are just familiar with the EAF Part 1, which is the form that the applicant will submit. It's filled out. They'll put the title of the project on there. They'll summarize what it is. They'll give some very basic information, and a lot of us often see that form. Some of us, though, don't see the Part 2 form, and a lot of us may never have seen the Part 3 form at all. But actually, all three parts of this form are important, and we should familiarize ourselves with them and make sure that they're used in the process. So the Part 1 of the form, again, is what identifies the project information. It's typically submitted by an applicant that's trying to do something and wants some approval from your town. So I want a site plan approval or a subdivision approval or a rezone. In my opinion, and the way that I put it in my towns, is your application is not complete with my town unless you provide a filled out EAF Part 1. The Part 2 is actually what you do as what whoever is on a municipal board here is what you would do as a municipal board member or a planner assisting a municipal board. The Part 2, if you're familiar with it, it's a form with a bunch of check boxes that says an issue like traffic impacts, and then one column says no or small impact, and the next one says moderate to large. That is some of the hard work that you get to do when you do a SEQR review. And this is the initial assessment. It's important, and it's used to identify both the categories and the magnitude of a range of potential impacts. So for example, on traffic, you might check no to small, or you might check moderate to large. And then for land impacts, you might check no to small, or you might check moderate to large. And for endangered species, you might check no to small, moderate to large. You go through all the different categories, and you see where you end up. There's actually two types of forms. There's the long form and the short form. And the long form is much longer than the short form. The short form is, I think, a couple of pages, 1 or 2 pages. I think it's just 1 page, actually, the Part 2. And the long form is many, many more pages. And there's many, many more questions that you have to answer no to small or moderate to large. So once you fill that out, that Part 2, and you approve it as a board, the last part is the Part 3. And the lawyers refer to this as the reasoned elaboration. The Part 3 form is really just a half page of instructions and then an empty box is essentially what it is. And it says, basically, tell us whether this has a potential significant adverse environmental impact or not, and give us your reasoning why. That's what it is. So basically, it's attach a bunch of pages to it if you really want to give us information, because the box is so small, it's a quarter or a third of a page. But it's important. That's a very important part of the process. And that's sort of the third line here of of the flow chart. So on that part 3, it's important for you to explain why, for example, you may have checked moderate to large on that part 2 form, but decided that there are no significant impacts, and so on. So step 4 is at the end of the part 3, you either say you're making a positive declaration or you're making a negative declaration. Actually, I've got that as 5. Part 3 is filling out the forms. Number 4 there is telling you the reasoning behind the forms and making that determination of significance. When the courts look at SEQR analysis, they look to make sure that the municipality did 3 things. They look to make sure that you identified the relevant areas of environmental concern, you took a hard look at them, and you made a reasoned elaboration. That's sort of court speak for did you do your job in the SEQR world. So the EAF allows us to do that. The EAF sort of streamlines, and if you fill out the parts 1, 2, and 3 of the EAF, it kind of streamlines that process and sort of ensures that you check off all those boxes, because that part 2 with all the check boxes helps you to identify the issues, right? If you check moderate to large next to traffic, you're identifying the issues like the court wants you to do. And if you analyze and write up that paragraph on the part 3 as to why you came to your determination, you've now taken a hard look and you made a reasonable elaboration. So that's why those parts 2 and 3 of the EAF are so important. It lets you set up your record so that you can defend your SEQR challenge if there is one. And that's what happens in the part 3, those last 2. So after you get done with your reasoned elaboration, your part 3 narrative, you decide whether you're going to make a negative or a positive declaration. A negative declaration it's kind of backwards. Some people think if it's positive, that's good, right? Negative is bad. In the case of SEQR, a negative is actually good. A negative means that there isn't any further environmental review required. So a negative declaration means that you found that there's no likely significant adverse environmental impacts, and then you're done with SEQR. A positive declaration means that the action that's proposed is likely to have significant adverse environmental impacts. And then you need to go on to a much longer process that can take months to years. And that's the environmental, the EIS. And we're not going to go into that because we could do a whole seminar on completing the EIS, the environmental impact statement. Okay, so why we're all here today is to look at the updates to the SEQR regulations and some newer case law that's come out over the past year or two. So SEQR lawyers got really excited over the past few years because the DEC said they were adopting changes to SEQR regulations. And that hasn't happened since 1995, so it's been a really long time since the SEQR regulations have been changed. They were actually rolled out a few years ago. There was public hearings. They actually, interestingly, did a SEQR process on the changes to the SEQR regulations and completed that. And they adopted the changes in the middle of 2018, and they became effective in January 1st of this year. The intent, the DEC tells us, was to streamline the process without sacrificing meaningful environmental review, and I think they did that. For me, sort of the exciting or the big deal here is that they actually changed the SEQR regulations. The changes they made, a lot of the individual changes aren't big groundbreaking changes, although some of them are going to have some big impacts. But there are a lot of smaller changes. Again, there are a few bigger ones, but there are a lot of smaller changes that we want to take a look at and just make sure on our radar. The DEC told us during this changing of the regulations that they saw this as the third step in modernizing SEQR review. The first step was they actually updated the EAF forms that I've been talking about, and they made them electronic. So actually that's for me is huge. It's nice that you can go on, print it off and go in and fill it in and type it in a PDF. The other thing you should know about in connection with electronic EAFs is that they actually have what's called the EAF mapper. Raise your hand if you know what the EAF mapper is. Oh, good. Okay, yeah, almost all of you know what it is. All right. So when you take an EAF Part 1 in, I would urge you to make sure that there's a certification on there that they use the EAF mapper. If they use the EAF mapper, which is an online tool that pre-fills a lot of that Part 1 EAF. For example, are you in a historic district? You know, some first-time developer might just check, no, I'm not, I don't think so. The EAF mapper will check a database, and if it is in a historic district, it will automatically check that box off. And then it will print a page on the end of the EAF Part 1 that we talked about, telling you that the EAF mapper was used, and also telling you what parts of the EAF were automatically filled in by the EAF mapper. So make sure that page is attached so that your EAFs that you're looking at are accurate. So that was the first step in modernizing. The second step are the EAF workbooks, which I think are great. I like the EAF workbooks. They give a lot of examples. They give a lot of narrative in explaining what substantially contiguous might mean, for example, or what a significant traffic impact might look like. They can be really helpful in trying to go through the parts 2 of the EAF and figure out, should I check low, no or low, or moderate to large. So I would urge you, if you haven't used the workbooks and you're looking at an issue that you just can't decide on, they are really helpful. So that was a recent thing that the DEC did. And then the last thing was these updates to the regulations. So the updates to the regulations, there are a bunch of them, and I didn't put every single one in here, but most of them are in here, are divided into really 3 main categories. That Type 1 list, which is there's a strong presumption of, or most likely to have a significant adverse environmental impact, so there's that list. And then there was also additions to the Type 2 list. And then there were some changes dealing with scoping and the preparation of a draft environmental impact statement. Okay, so we'll get into the actual substantive updates. The first is to the Type 1 list. We'll get into that first. The DEC, the new regulations that are now in effect and live, they reduced the Type 1 triggers for the construction of residential units and parking. So under the DEC Type 1 list, for SEQR regulations, once you build a certain number of residential units, depending on the population of the municipality they're built in, it will cause it to be a Type 1 action if you build enough of them and or parking spaces. So for cities, towns, and villages with a population at or under 150,000, it now says that the addition of 200 residential units connected to existing public water or sewer causes it to be classified as a Type 1 action. It used to be 250, so they reduced the threshold a little bit. Now more smaller residential projects are going to be Type 1 actions. What does that mean? That means that, first of all, it means they need to fill out that long form EAF instead of the short form. So they're going to have to do a lot more homework, and so are we. But it's going to give us a lot more information upon which to base our SEQR determination, and our record will be a little thicker and probably a little more defensible if we issue a negative declaration. So there's going to be a little bit more review on these now, but we're going to have more information upon which to base our review. For the non-residential projects, the trigger is now the addition of parking for 500 vehicles down from 1,000. So before, you had to have parking for 1,000 vehicles to trigger a Type 1. Now it's just 500. They cut it in half. I always thought 1,000 was pretty high threshold to meet, so 500 feels a little more right size to me. And again, that's for municipalities under 150,000. Now for municipalities greater than 150,000, but less than 1 million in population, for non-residential, the addition of 500 residential units triggers a Type 1 action that's down from 1,000, so they halved that. And they need to be connected to existing public water and sewer. And then the last change in this category of residential and non-residential construction is when you get to the threshold of more than 1 million population, you need to go, it's 1,000 residential units that triggers a Type 1 action down from 2,500, so they substantially reduce that trigger. So we're going to see more Type 1 review of residential and some non-residential projects. You know what? That should say for residential. Yep. Sorry about that. Okay, the next section here is dealing with historic resources. So before this update, SEQR required any unlisted action, regardless of size, to be elevated to a Type 1 action if it was located on or substantially contiguous to a property listed on the National Register of Historic Places. So that means unless it was a Type 2 action, so the action that was proposed, unless it was a Type 2 action, if it's not on a Type 2 list, then it's going to be a Type 1 action if it's on or substantially contiguous to a property on the National Register of Historic Places. That's how the old regulations were prior to January of this year. But this year, the new regulations updated and added a threshold to this section so that only unlisted actions which are on or substantially contiguous to a historic property and which exceed a Type 1 which exceed 25% of a Type 1 threshold will be elevated to Type 1. So we've significantly reduced the types of actions that are going to trigger this. But also, they added some actions that will trigger it by, instead of just saying that only dealing with properties that are actually on the National Register of Historic Places, it also triggers from properties that are deemed eligible for inclusion on the National Register of Historic Places. So they kind of balance it out a little bit. I think this also kind of right sizes this section as well, because you might have a very minor project like some minor side setback variance on a parcel that's in the vicinity of a historic parcel that doesn't have any impact whatsoever. It's on the other side of the parcel, away from the historic property, but just because it's in the vicinity of a historic property, it's a Type 1 action. Now we're going to make sure. Now we're only going to Type 1 these kinds of actions if they exceed 25% of a Type 1 threshold. What does that mean? Think back to the last slide where we were talking about 200 residential properties trigger a Type 1 action. So if we have 50 residential properties, we're at 25%. If we have 50 residential properties contiguous to a historic property that are going in, that would trigger a Type 1 action. That's how that would work. The other interesting thing I just want to bring up here, this isn't new, but it's something to note. SEQR actually lets you customize your Type 1 list. So SEQR has its own Type 1 list, but you can actually make your Type 1 list sort of more stringent. You can make it so that more actions trigger Type 1 within your local code. So that's at SEQR 617.4A2. So if you think that 25% is too generous, you could say, well, if it's 10%, then it triggers a Type 1 action. So instead of 50 properties, now you're talking, if you build 20 residential units near a historic property, you're a Type 1 action. There are a bunch of changes also. Oh, go ahead.
Can that be reduced down to 0%?
Yeah.
To bring it back to something?
Yes. So the question was, can you just remove the threshold altogether? Can you just remove the threshold altogether if you have a custom Type 1 list? Can you just undo basically what the DEC did and take that threshold out? Yeah, you could theoretically take that threshold out and say anything that's on or near or substantially contiguous to a historic property is a Type 1 action. Right here?
How is the eligibility determined? Is that the responsibility of the board?
Yeah, that's done at the state level. There's a process that we could get into, but it's another step in the process. In the back?
My question was very similar to his, but could a project be challenged if it's eligible and then sent to the Historic Preservation Office for a determination after it goes? Does the site have to be eligible prior to the SEQR review?
The question is, in order to trigger this, does the site need to be deemed eligible, I guess even be on the historic register prior to your SEQR review? That's a good question. I suppose it's not going to trigger the review if it's not in there in the first place. So it certainly makes things more complicated. What I would think about doing in that case, if there's a property, say, not on the historic register, when you begin your review of a project, and say the review takes a few months or many months, you get halfway through your SEQR review, or halfway through your rezone or whatever underlying substantive review you're doing, and the project is deemed historical, that might merit you to revisit SEQR, actually. That would probably be the safest move there. Of course, the developer wouldn't like that, but that would be probably the most conservative move by the municipality, because we'll talk about this a little bit later, but when there are new changes in circumstances or changes to a project, that merits you revisiting SEQR. And in this case, that would be a change in circumstance. The project would have been changed at some point during your SEQR review, meriting revisiting of that topic.
Just a point of information, I work for state parks and historic, but the properties could be state listed, so on the state
Mhm.
register, but not necessarily on the national register.
Mhm.
Properties can be locally landmarked, but not necessarily on either.
Mhm.
So there is a distinction, and you have to actually be mindful of that.
Yep. So just reminding us that there's different types of historic designations. There's federal, state, and local. So that's something you want to be mindful of when you're conducting these types of reviews.
And this rule only applies to the national register.
National Register of Historic Places, yep. So if you want to add, I think it's actually state as well, and if you want to add local on there, you can do that on your custom type 1 list as well. That doesn't include local, but it does include state and national. So if you want to add local, you'll want to put that on your type 1 list. Say again?
This does include.
My understanding is it does include state.
And stand for state also.
Yes. On other updates to the Type 2 list, there have been a number of minor amendments to the Type 2 list that might have given us headaches in the past, but now they're clearer to us. So simple lot line adjustments are Type 2 actions. Building upgrades, just for the purposes of meeting energy codes, would be considered Type 2 actions. Recommendations coming out of General Municipal Law 239M, which is a county planning board review of a project. Those would be Type 2 actions. Dedication, dealing with parkland and conservation easements less than 25 acres, Type 2. And then installation of telecommunication cables in right-of-way, as long as they're buried or in existing poles, would also be considered Type 2 actions.
Can I just go back?
Yep,
When you're talking about the reduction of type 1 triggers,
yep.
do you need both public water and sewer? Just like in our town, we don't have a public water, we only have wells.
I believe the regulations say, okay, so the question was, when we're dealing with these triggers on this slide here for residential construction, do you need does this trigger from public water and sewer, both? I believe the regulations actually say and there, they don't say or. I don't have them right in front of me. I could pull them up, but I'm not going to do that right now. I believe they do say and, you want both. There are other triggers when you're not dealing with public water and sewer, though. So there are other triggers when you're not dealing with public water and sewer, but those weren't changed. Only this trigger for the public water and sewer residential units were changed. Yep.
What's the definition of substantially?
That's a great question. So what's the definition of substantially contiguous? That's why there are lawyers in this world. So I believe, though, in some circumstances that substantially contiguous, that question you asked is elaborated upon within the SEQR workbook I referenced earlier on. So for some questions, if you look at whether a property is considered to be substantially contiguous to a historic property, if you look that question up, if you go to that regulation in the SEQR workbook, it will expound upon that and give you examples in some situations. So that would be my answer to that question. I'm sure there's case law as well that we could get into that goes all over the place on what we would be substantially contiguous, but I would start with the workbook on that question.
What sort of a general good practice?
As far, I didn't hear the question.
Good practice for substantial.
So what is a good practice for substantially contiguous? So I would certainly say, if there's a property that's adjacent to a historic property, that would certainly be contiguous. If it's within a historic district, I think there's a good argument if it's within this view shed that it's substantially contiguous. But let's remember that when what we're talking about right now, these type 1 and type 2 lists are classification lists. So if we're not sure whether a property is substantially contiguous to a historic district, that doesn't preclude us from digging into a SEQR review. In other words, if we classify it as unlisted, right, we can still pause DECIT and go through a lengthy SEQR analysis. Whether we classify it as a type 1 action or an unlisted action, we can still dig into the environmental impacts on the historic property. So it's still good to get it right. It's still good to ask the question and make sure we're doing our due diligence. But the classification doesn't necessarily dictate where we end up. It sort of is the starting point. Okay, so more changes to the type 2 list. Green infrastructure was added, a provision regarding green infrastructure. It's defined as the retrofitting of existing, or the addition to the type 2 list is retrofitting of existing structure to incorporate green infrastructure. And then green infrastructure is defined here as practices that manage stormwater through infiltration, evapotranspiration, and reuse, including, and then it says only the following, so it's limiting this: the use of permeable pavement, bioretention, green roofs and green walls, tree pits, urban forestry, stormwater planters, rain gardens, vegetated swales, downspout disconnection, or stormwater harvesting and reuse. Again, that's to an existing structure, which is why it's a type 2 action. So another addition to the type 2 list: reuse of residential, commercial, or mixed use residential and commercial structure where the use is permitted under the applicable zoning law. So that's an important thing. It's permitted under the existing zoning law, included by special use permit, and it does not meet or exceed any type 1 thresholds. So again, we're dealing with a built building. We're not building another building. It's an existing building that we're reusing for a different type of use. And then in reading the documents of the DEC assessing their own changes, they talked about how a common phrase among green building advocates is the greenest building is the one that's never built or that isn't built. So here they're trying to play that out by saying, fix up your existing buildings, reuse your existing buildings, make them greener, and we're not going to subject you to SEQR review. They also, they cited the benefits of reusing existing buildings or making them green. There's less, instead of demoing an existing building and rebuilding it, if you just reuse the building, there's less materials that are going to be used. You're putting less stuff into the landfill, so on and so forth. So this is how they're justifying adding these things into their type 2 list. Oh.
Typically, there'd be some amount of construction involved with reuse.
Absolutely, yeah. The comment was even in the case of a reuse, you're going to have some construction. Sure you are. But you're going to have, in the reuse situation, you're going to have more labor and less materials. Or you're going to have less materials in the reuse situation. You're going to have many more materials when you demo and rebuild altogether. Okay, another addition to the type 2 list is the addition of certain types of solar projects. So again, this is the type 2 list. It doesn't require SEQR review. So this involves the installation of solar projects less than 25 acres of physical alteration, but only on the following types of sites. And as you see, if you look through the sites, it makes sense. They're incentivizing putting solar on sites that really can't be used or can't be used easily for other types of projects. So a closed landfill, certain types of commercial or industrial brownfield sites or environmental restoration sites, certain certified inactive hazardous waste sites, currently disturbed areas at publicly owned wastewater treatment facilities, currently disturbed areas in industrial zones. So I think those last two I just read, it's important to highlight currently disturbed areas, right? Because there are plenty of industrial zones that people would like to build solar on, but we're only dealing with currently disturbed areas, not green fields and buffers and trees and things like that. They're areas that have been disturbed already. Parking lots or parking garages, the DEC sees those as good options and good places to put solar, enough so that their type 2 action is not subject to SEQR review. So these are kind of a big deal, I think. The other type of solar project that would qualify as a type 2 action is an installation of solar on an existing structure, so long as the structure doesn't trigger isn't on the National or State Register of Historic Places. Question in the back? I'm saying that solar projects that are less than 25 acres in size that are proposed on these types of sites on this slide would qualify for a type 2, yes, and they would not be subject to SEQR review. Yep. I mean, assuming all other things are equal and that's all they're doing, this is the intent of this regulation, to encourage solar on these sort of less favored sites. No, you see, if you look at the list, there's no agricultural on this list. Yeah, they have to be only on these sites that are listed on this slide. Mm-hmm.
One thing that can trigger that is the access road, the width and length of it, even if the line is under the 25 acres. We just went through that, so.
Okay. All right. Yeah, she was just describing something else that isn't on the list. Yeah, okay. So if there's a solar project that's proposed on on a farm, for example, and it's 20 acres, it doesn't come into this exception, because this exception only applies to the 1, 2, 3, 4, 5, 6 items here. Only those 6 types of land situations. So closed landfills, brownfields, waste disposal sites, currently disturbed wastewater treatment plants, and currently disturbed industrial zones, or parking garages. It depends. So the next question was, would that be a type 1 or unlisted action? It depends on the type of solar project that it is. So we'd get out the type 1 list, we'd compare the solar proposal, and see whether it triggers any of those, whether it matches up with any of those type 1 actions. If it doesn't, then it would be an unlisted action. Yep. Mm-hmm. Yeah. So we've got some interest in solar here. So the comment was the only sort of implication when we're classifying here is whether you use the long or short form, which is something that we talked about a few minutes ago, right? I said that when we're dealing with classification, but ultimately, whether you classify something as unlisted or type 1, you can still subject it to a full SEQR environmental review. It's only when you put it in the type 2 bucket that it's not subject to SEQR review. If you classify something as a type 2 action, you're done with SEQR. So that obviously has an impact. But whether you classify it as a type 1 or an unlisted action, you can still carry through a complete SEQR review. The difference is DEC sees a type 1 action as more likely to have a significant adverse environmental impact and more likely to merit the full SEQR review, a draft environmental impact statement, a final environmental impact statement, finding statement, and all that, a pause deck. So if it does carry that type 1 classification, we might say that it's more likely to merit a positive declaration and a more thorough, comprehensive SEQR review as opposed to an unlisted action. But you can still require, for an unlisted action, for example, you can still require a long-form EAF for that. So it does matter, but it's not the end of the story when we're picking between a type 1 and an unlisted action. Okay? In the back?
So with that said, you want to be careful when you're categorizing that you don't categorize an unlisted action as a type 1 action. In fact, it is unlisted because you open yourself to potential legal action from the developer.
Yeah, so the comment was we still want to do our best when we're classifying, because then you have the potential to upset the developer and have legal action. So if you classify something that should be unlisted as a type 1 action, is the developer going to sue you right then and there? I don't think in legal terms that it would be ripe at that point for a lawsuit. But somewhere down the line, if you pause DECID and you shut down the project and you deemed it type 1 when it should have been unlisted, that might be a factor the developer might bring up. But what's probably really going to sink you is the actual analysis as to why you said no. Either you said no because there are actual significant adverse environmental impacts that weren't properly mitigated that when they could have been, or there weren't any, and you should not have declined to move forward with the project. So yeah, there's a lot of factors that can come up. We always want to do our best to classify things correctly and build our record correctly. In the back?
Banks and markets protect the farmer with solar installations. The problem becomes for the farmer when he hooks it to the grid and he's trying to sell his excess over to the, then he's not protected by ag markets from that line from his stuff to the public grid.
So someone had the question deals with ag and markets and solar. I think I should have presented on solar today instead of SEQR updates. It's actually funny because I do a lot of work with solar developers and I write a lot of solar codes. But I don't want to go too far off track on the solar stuff. I just want to let you know, though, that solar projects are subject to SEQR unless they're a type 2 action. And they will be the bigger solar projects that are up to 25 acres can be a type 2 action if they're on this list. If they're not on this list, let's look at the type 1 list and see if they trigger that. Let's look at the other type 2 actions, see if they fall in there. If not, they're going to be unlisted, and then we're going to proceed with our SEQR review just like any other project. Okay?
One other question. What about, what's the difference as far as SEQR goes between ground-mounted and roof-mounted? Is it treated the same?
Okay, last question for now on solar. Is there a difference for SEQR purposes of ground-mounted versus building-mounted? Now there is, yeah. The last sentence on this slide says that installation of solar on an existing structure, so long as it's not eligible for or listed on the National or State Historic Register, will be a type 2 action. So there's a significant difference now. And we're going to go on to the next slide at this point. Zoning is different than SEQR. That's right. Mm-hmm. Okay, so there's also changes to scoping and the draft environmental impact statement with these regulations. So prior, does every raise of hands, who knows what scoping is? Okay, good. All right. So then you probably all know that prior to the update, scoping was an optional step, which to me was somewhat confusing because if you're going to go so far as to pause deck something and make people do a draft environmental impact statement and a final impact statement and maybe revise their draft environmental impact statement a bunch of times, why wouldn't you just do a scope and do it that way? So scoping is essentially outlining the significant issues that need to be examined once you issue a positive declaration. And prior to the changes this year that were effective this year, a scope was optional. Well, the amendments now make the scope mandatory, which I think is great. It clarifies things for everybody because now everybody knows what needs to be assessed in that draft environmental impact statement. The developer knows and the municipality knows. So the DEC said in doing this, we're probably going to end up with shorter, tighter EISs that really focus on the relevant impacts. They're going to eliminate some of the irrelevant issues from the draft environmental impact statements. You know, if you look at some draft environmental impact statements, they can go on and on and on and on and on, and some of the stuff, a lot of the stuff in there doesn't really matter. We all know oftentimes when something is paused decked, it's because of an issue, a particular issue. Sometimes there are many issues, but there's usually a few issues that really matter. And if we go on and on and on about all the issues that nobody cares about and doesn't have anything to do with our environmental review, we're really doing ourselves a disservice because we issue a draft environmental impact statement for public review. Now the public is reviewing a 300-page DEIS that only needs to be 100 pages. You're getting comments on all 300 pages. You're having to revise it all. It gets to be quite a process. So I do think that this scoping is really going to help us in our efficiency in focusing in on those issues that really matter. The other thing is they wrote right into the regulations that if issues are checked off on the EAF or discussed in the EAF Part 3, as moderate to large, but they're not in the scope, that you've got to explain why they aren't in your scope. In other words, if you check on your boxes for EAF Part 2, if you check there's going to be a moderate to large impact on the land, for example, but then you don't scope out an assessment, environmental assessment on the land for your draft EIS, you've got to tell us why you did that. Why did you check moderate to large, but then not require us to assess that in the environmental impact statement? So that's also a new addition to the regulations. Okay, a few other changes dealing with the draft environmental impact statement. So they clarified the requirements for a complete DEIS. There's a sort of a list in the regulations. Go take a look. They clarified what's required in order to have a complete DEIS for legal purposes. And they also clarified the process for when a DEIS has to be resubmitted, which is the next bullet there tells us a little bit about that. The adequacy of a resubmitted DEIS must be evaluated solely on the written list of deficiencies, unless there have been changes to the project or new information or circumstances. So this is also nice that the DEC didn't say this clearly before in the regulations. Now they've come out and they've made it clear. I've been in situations where a DEIS is rejected, and it's not necessarily clear why it was rejected. So we go and we spend a month or two revising it, and we come back and it's rejected again. And we go and revise it and reject it again. And you go on and on and on. Now the DEC is telling us, and this is good for us municipalities to take note of, we need to be clear about why, if and why we reject a DEIS. We need to have a clear list of why. Make sure you don't leave anything off that list, because if you reject a DEIS and you don't put all the points you want on your rejection letter, then the developer isn't required to address items you didn't put on your rejection letter. So make sure that your rejection letter includes all of the issues and all of the deficiencies with the DEIS, because that now narrows the scope of things the developer has to do when they resubmit a DEIS, unless there were changes to the project or a new info or circumstance. So this is what I was talking about before. You're going through a review, you pause deck something, and a DEIS is submitted, and then it's made eligible for the National Historic Register or State Historic Register. That actually doesn't necessarily need to be on the list. That automatically triggers a revision in the DEIS. It's not limited to be on that list. I would still put it on the list. There's no reason not to. If you reject it, to say, hey, look, now you're on the historic register. Now you've got to address historic impacts as well. You might as well put it on the list to be safe. They also added, there are a bunch of items that need to be addressed, as I told you before, in the regulations, in the DEIS. They added an additional item, which is there at the bottom of the slide. Measures to avoid or reduce both inactions, environmental impacts, and vulnerability from the effects of climate change, such as sea level rise and flooding. I'm curious to see how that's going to be responded to. On a micro level, when someone's building, I don't know, a small apartment building or something, I'm not sure exactly how that's going to be responded to by a developer. I suspect you're probably going to start to see a lot of similar language in there about green practices and things like that to deal with this. I'm not sure how else they're going to deal with it, but I'm curious to see what kind of new information this requirement is going to trigger in the DEISs that we might see. Question?
Two quick ones. Regarding that last point, is this something required to be covered in the DEIS even though it wasn't on the scope? That's question one. Question two, does this add anything to either the assessment forms?
I don't know that it added anything to the assessment forms. But I do believe that, yes, it is something that needs to be addressed in the DEIS regardless. There are a bunch of categories of items that need to be addressed and items that essentially need to be checked off on the DEIS, one of which is something as simple as a table of contents. So I do think there are other issues like irretrievable losses of environmental resources, things like that. So it might be a very brief response, but that's my understanding. Because it's a requirement of the EIS, period.
But in deciding whether to protect something, this would be relevant.
No, not necessarily. Well, it might be relevant under one of the existing categories of the EAF Part 2, but it wouldn't necessarily be a standalone item to assess at the EAF stage, is the way that the DEC sees it. Right. Right. So the comment was, if you're in a floodplain, that's the question on the EAF. Yep. And that might affect flooding, for example. There are other things on the There are other things to assess on the EAF, like whether it's going to require additional whether there's sufficient power to power the project. I don't know the exact verbiage, but it's essentially, do you need to build a new substation if you build this project? So that's something you would check off on the Part 2. And then you're going to end up addressing this topic in the EIS probably because, hey, now we've got to expand electrical production in order to allow you to build this project and power it. So it gets there, but it's not a direct connection.
Going back to the scoping changes, I think I saw on the DEC website that another change had to do with who prepares the draft scoping outline once it's required, that now it's the applicant's responsibility to do that. Is that correct?
I actually don't recall if that changed offhand, but I can look into that and get back to you. Okay.
I know in the past that it could have been either the lead agency or the applicant.
Yeah.
On an agreement. Now it looked to me like it says the applicant shall do that.
So the question was whether the scope itself can be prepared by the applicant, whether there's an option for the applicant to prepare it or for the municipality or the lead agency to prepare it. That is the case for the draft environmental impact statement. Either the applicant or the lead agency can prepare it. As far as the scope, I'm not 100% sure whether the scope can now be prepared by the applicant. I actually believe I did see that in there. I didn't add it into this presentation, but I think that actually may be true. So email me and we'll confirm that to be the case or not. Sure.
If you have a project, and you think you can give it a neg deck, but you have one issue, can you give neg deck with a qualification? Is there such a thing?
So the question was, if there's a project that you have just a single issue with, can you still give it a neg deck? There is an approach called a condition negative declaration. Yes, there's limited situations in which you can use it, but there is a situation in which you can use a condition negative declaration. In other words, if you do this thing, then it's not going to have a negative impact, and so we'll issue a negative declaration. Okay? Oh, next we have the case updates. Looking at time, I believe we started a little after 3, right? I know we changed the schedule. So we'll have enough time to get through these case updates on time here. So that ends the actual amendments to the SEQR regulations. And now we're going to just look at some cases from the past year or two that give us a little insight into sort of SEQR topics. So each one of these has a main SEQR topic I think that we can learn a lesson from. And again, was a case from the past year or two. So this first one here is Adirondack Historic Association versus the Village of Lake Placid, somewhat local. Dealing with segmentation. Segmentation is when you do multiple SEQR reviews for different aspects of a single project. By raise of hands, do you think segmentation is illegal? Yes? If you do, yes, raise your hand. Okay, wow. We've got some SEQR experts in here. So segmentation isn't per se illegal. It is allowed in certain circumstances. So in this case, the village proposes Lake Placid Main Street reconstruction project. They're going to redo their Main Street. They go through SEQR, they complete SEQR, they issue a negative declaration, and they hit a snag because there are some vacant parcels owned by the Historic Association. They're not being used by the Historic Association, but the Historic Association doesn't want to sell the parcels. So the village actually takes action via eminent domain to go and take those parcels. And then they go and they complete SEQR for the eminent domain action. So they hadn't anticipated having to do eminent domain in the first place. They thought they might be able to purchase the land or some other kind of cooperation with the Historic Association, but they didn't gain that. So this was sort of an unexpected step, having to do eminent domain to acquire these parcels. These parcels were important because they were going to be used as parking facilities associated with the Main Street reconstruction. So they actually look at this eminent domain on its own, because they hadn't thought about it in the first place, and they issue a negative declaration relative to the eminent domain. Historic Association sues. They say, you segmented the review, you did 2 SEQRs for the same project, your SEQR's invalid. So the court on the law tells us what many of you seem to already know, that there's permissible segmentation and there's impermissible segmentation. Impermissible segmentation is when you have a segmented SEQR review that acts to circumvent SEQR and it's less protective of the environment. Permissible segmentation is when you segment not for the purposes of circumventing SEQR, and when it is no less protective of the environment. And the DEC tells us actually that when you segment, you should tell us that you're segmenting up front. We are segmenting, and here are the reasons we're segmenting, and here are the reasons that it's going to be no less protective of the environment. Now, of course, here they didn't know they were going to have to segment. They didn't know they were going to have to carry out the eminent domain procedure, so they couldn't have told us up front, hey, we're segmenting, and here's why it's no less protective. That's obviously the best practice, but they didn't have a crystal ball here, so they couldn't do that. In any event, the court tells us that there is no impermissible segmentation here, because the need for the eminent domain procedure was unknown at the time of their initial SEQR review, and that this is language the court tends to use in these types of analyses, that they need not consider every speculative or hypothetical possibility in their SEQR review. If you had to think about every possible potential thing that could ever happen in your SEQR review, you'd never be done with your SEQR review. And so that's a point the court makes. But the SEQR was actually invalid on other grounds. The records showed that they failed to take a hard look and set forth a reasonable elaboration on traffic as it related to the parking garage. And again, they wanted to build parking garages on these vacant parcels. During the SEQR review for the eminent domain procedure, questions were raised regarding traffic coming in and out of the parking garage and the use of the parking garage, etc. And so the village simply checked no small on their EAF as it relates to traffic and parking, and that's all they did relative to their SEQR review for that eminent domain procedure. What they should have done in the court's eyes is either checked no small on the part 2, and then on the part 3 told us why they checked no small. We did a traffic study. That probably would have been the best way to do it. We did a traffic study. It showed that there's sufficient capacity on the road, et cetera, et cetera. Please see the attached traffic study on my part 3. They could have checked moderate to large and done the same thing. They could have paused-decked it. But if they wanted to check no small, the court says, well, you should have told us why you checked no small and why that didn't result in a potentially significant adverse environmental impact. Okay, Mickless versus the Town of Half Moon Planning Board. This one focuses on classification, which we talked a bit about earlier, and the record. So again, remember, classification is putting in our initial SEQR assessment, putting the action into one of those 3 buckets, type 1, unlisted, or type 2. So here, a golf course receives site plan and special use permits approvals in 1999. Then in 2017, they apply for an addition. They want to build a restaurant/bar/brewery on the golf course. So this is, many years later, almost 10 years later. The residential neighbors oppose. They say, this is going to impact our neighborhood negatively. And the planning board actually initially classifies this as a type 2 action and approves the project, but their resolution cites to the project as an unlisted action. So their initial resolutions cite to this as an unlisted action, and their initial SEQR documents, cite to this as a type 2 action, but then their final approving resolution cites to it as an unlisted action. So they're inconsistent here. And they approve a negative declaration. So there's a couple, obviously calling it two different things for the same project is an issue in and of itself. What's also strange is that they issued a negative declaration for something that they initially called a type 2 action. You would never do that, right? Because a type 2 action isn't subject to SEQR, and it would need a negative declaration. I see that happen a lot in towns that aren't familiar with SEQR and in other smaller municipalities. They'll issue a negative declaration for type 2 actions. That doesn't really align with SEQR regulations because it's not subject to SEQR review. In any event, the neighbors see this issue and they sue. They say you didn't complete SEQR properly because of this inconsistency. So one of the things the court focuses on, instead of the classification actually, is that SEQR requires a reasoned elaboration on the record. That's kind of what the court homes in on here. So the court starts its analysis, or really digs into the analysis of what's on the record for your SEQR review. It doesn't so much focus on the classification as unlisted versus type 2. It focuses on what did you actually do for your environmental review. And so the court tells us what they did. They sought public input. They sought input from safety officials and other agencies on the environmental impacts of the addition. The planning board on the record, likely during a public hearing, found that the project was limited in size and was limited to already disturbed areas on the golf course. The planning board on the record addressed parking issues and addressed issues associated with disposal of some of the byproducts of the brewing. And so the court found, regardless of this inconsistency, that the record itself was sufficient to uphold their negative declaration. So, the best practice is obviously, like we were talking about, half an hour ago, is to make sure we do our best job and we do it accurately up front. We classify it correctly, and we end up with the right answer. But at the very least, as I was saying before, it's our actual assessment that the court tends to weigh the most. It looks at what did you actually do? How did you look at the environmental impacts? There are the three things. I think this will be on the next slide, but did you identify the issues? Did you take a hard look at the issues, and did you give us a reason for your determination, for your negative declaration here? That's what the court is really digging for when it's assessing a SEQR case. And of course, it does look at process. If you skip steps, you're going to get dinged. But it really looks mostly at that assessment we just went over. In the back? Yeah. Mm-hmm. Okay, so the question was back here on the Lake Placid case. Are we here? Yeah. On the Lake Placid case, if they checked no to small on the EAF Part 2, why did the court ding them and require them essentially to do a Part 3? Because you don't need to do a Part 3 for a no to small. You need to do a Part 3 for moderate to large. So the instructions on the Part 3 do tell us that for anything you checked moderate to large on, you need to assess that in the Part 3, especially if you're not going on to a positive declaration. I think what the court is telling us in this case is they probably shouldn't have checked no to small in the first place, that there were issues that were moderate to large. And this is another case where I'll ring the bell on the workbook, or the handbook, I should say. The handbook, when you look at a particular question on the EAF, it will give you some examples of what types of factors might indicate a no to small versus a moderate to large. And so here, I think the court is saying that you didn't really justify your no to small. I think if they would have checked no to small, and then they would have went on their Part 3 and said, here's why we checked our no to small, they would have been okay. If they checked moderate to large and they went and said the same exact thing that would have been okay under the no to small, they also would have been okay. What it seems like they did here was they said, you know what, we heard your traffic concerns. We don't really think they're an issue based on our gut, based on, you know, our non-expert review of it. And so we're done with our SEQR review. And that wasn't enough for the court here. They saw the record. They saw some of the issues that were raised probably during the public meetings, and they said you needed to dig into those issues. A lot of times when a project is challenged, and I don't mean legally challenged, but when people show up to oppose a project to a public meeting, what I find is a lot of times people will show up and they'll just sort of complain, and they will tell us why they don't like the project, but they won't give us any evidence-based facts as to why we should dig in more on SEQR or why we should shut down the project. They'll just tell us, you know, we don't need another pizza shop, or we don't need more apartments, or we don't need this, or we don't need that. I don't want that in my backyard, right? So sometimes people will show up and they'll oppose and they'll give us this general opposition, which isn't enough to basically take action on SEQR. But other times, people will show up and give you actual evidence-based factual information that you can use in your SEQR review. And I think in this case, the court is saying, we heard some real concerns that made sense to us, and you should have assessed those concerns, and you didn't. And so for that reason, we're overturning your SEQR, we're nullifying it. Okay, so back to that Half Moon case. They incorrectly classified, or they not necessarily incorrectly classified, but they gave two different types of classifications. But the court said, we'll forgive you for that because you actually still completed your assessment and you came to the right determination based on that assessment. One thing I do want to say about the record is the case to me didn't make clear what the record was here. And in a lot of times people will think, well, the record is, you know, the filled out forms, the written submissions, if there was a stenographer, whatever was taken down during the public hearings. The record is anything anything that's submitted and that's relevant to the case, and that includes public comment, that includes board discussion as well, whether it's written or not. There should be minutes, of course, so that you can substantiate that record, because if it's not captured, then there's no way you can prove it happened. But the record includes all of that. It includes letters that are written from residents. It includes expert testimony, expert reports. So the record is really a compilation of everything there. And so that's what the court looked at. It looked at everything all together, not just the EAFs, not just the misclassification, but it looked at all of the discussion. And I'm guessing, based on the way the court framed this, that there was a lot of substantive discussion during the public meeting between the board members. Which is good, but my recommendation is put that down in your part 3. Record that in writing, because minutes from town to town and village to village and city to city are different. Some people summarize them, some are verbatim, some are recorded on a tape, some aren't. It's best really to have a written determination with a written part 3 that really fleshes out what you mean to say, so that it's accurate and clear. All right, next case, Worcester versus the Queen City Landing LLC, City of Buffalo. This is about experts in review standard. Again, we talked about the SEQR review standard, the identify, taking a hard look, and a reasoned elaboration. In this case, the developer wants to build in Buffalo a mixed-use project that includes a 23-story residential tower with 200 units. And I just realized this, but it's interesting because it would now trigger a type 1 action under the new regs, but it wouldn't have under the old regs. So it's subject to SEQR review. It's subject to local review for the Buffalo Planning Board and another sub-board called the Common Council. They actually review things when they're near the water, so they do a coastal review. The Planning Board declares itself lead agency, and the City of Buffalo Planning Department, I think as is part of their typical process, prepares the EAFs parts 2 and 3. So the Planning Board gets their package, probably as most of us do, which included those EAFs parts 2 and 3 that was prepared by the planning staff, and they issue a negative declaration based on those documents that were prepared by the planning staff. And the Buffalo residents sue first they say, like they all do, that you just generally didn't do a good review of SEQR. You didn't identify and take a hard look and issue a reasoned elaboration. But then they also say that you improperly deferred your SEQR review to your planning department, because your planning board filled out those EAFs Part 2 and 3, not you. So again, the court recites the SEQR standard that we've been talking about, and it also tells us that the lead agency is entitled to rely on experts during their SEQR review. And then the court says we're going to uphold that negative declaration. The planning board's reliance on those EAFs and the fact that their planning department staff prepared them was not improper. The planning board's preparation of the EAF essentially amounted to information from experts, and the planning board did review and approve the EAF itself. So I almost think the court didn't even need to go that far, that calling the planning board staff experts, which is great. If they can be experts, that's fine. But the analogy I would make is this: a lot of times I'll prepare a resolution for my board to adopt in advance. Sometimes I'm taking a shot in the dark, and sometimes I'll prepare 2 resolutions and approve for this reason or disapprove for this reason, and they get to decide what they're going to do. But just because I wrote that resolution doesn't mean they improperly deferred their authority to me. It's still their responsibility to decide whether they're going to approve it or not. In the same way, just because the planning staff prepared an EAF 2 or 3, that doesn't mean that was deferred to the planning staff. The planning board still gets to decide whether they're going to actually go with that 2 or 3. The planning staff didn't approve the parts 2 and 3. The planning board just gave them draft parts 2 and 3 for their consideration. So that's the way I really view this. In fact, sometimes a developer will actually submit a parts 2 and 3 with its application and hope that the planning board will go with it. And sometimes that might be appropriate and sometimes it might not. But that doesn't mean that you deferred your review to somebody else. It's information you got. You can decide to adopt all of it, some of it, part of it, none of it. So I think that's an interesting view of things. The court then goes on to tell us how the planning board looked at all kinds of different aspects. And this again highlights that it's the substance of the review that the court really takes into consideration. The court goes on, even though it touched on that EAF issue and the fact that it wasn't an improper deferral, it still goes on and tells us also, by the way, here's what the planning board did. It looked at aesthetic impacts and community character and height of building and all these other things, and that it wasn't required to consider every conceivable impact. That's another point we saw in a different case. So as long as you're doing your hard look and your reasoned elaboration, you should be good. And obviously you've got to follow the proper procedure. But you can certainly take input from your staff. They can certainly prepare your parts 2 and 3. You've got to make sure you look at those parts 2 and 3 and actually approve them by a majority. Okay, I think I have 2 more. So matter of Green Earth Farms versus Town of Haverstraw P Planning Board. This gets into changes. It's something we've talked a little bit about today already. In 2004, developer wants approvals for a mixed residential and commercial development on a 50-plus acre parcel. And during about a 4-year period, the planning board issues a positive declaration for this, an EIS, a draft and a final EIS, a finding statement, etc. And ultimately, the SEQR allows the development. But they completed the SEQR, which is a prerequisite to the underlying substantive land use review, like site plans and subdivisions. So they completed the SEQR, but they didn't complete necessarily all the land use approvals. In 2012, the developer comes back for final site plan approval on the project, but as often happens, actually, there are some changes, some tweaks. They want to add a 7,000 square foot store and 16 gas pumps. The planning board looked at this proposed change, said it's a minor thing, we don't need to revisit SEQR, we already went through all that, and then they approved the site plan. The neighbors sue. They said, you know what, you should have done additional SEQR review because of the addition of the store and the gas pumps. SEQR should be nullified. So here, this type of analysis can apply whether there's a positive deck or not. If there's a change to a project, we need to go back and look at whether our underlying SEQR review addressed sufficiently the topic that we're talking about. Here, since there was a positive declaration, they're talking about something called the supplemental environmental impact statement. But again, the idea is that if there is a change after the fact, we want to go back and look and make sure that whatever SEQR we did, regardless of whether we negative decked it or pause decked it and went through the EIS, we need to make sure that our underlying SEQR addressed the topic associated with the change. So here the court says, the court recognized that the developer argued the supplemental SEQR would not be required because of a permitting process of the New York State and the Department of Health for gas stations. So basically the developer said, hey, don't worry about it. We still need to get all these permits from these state agencies. Not a big deal. We didn't need to go through further SEQR review. But the court says that doesn't matter. You can't just say, planning board, that another agency is going to do your environmental review. You are the lead agency, not the Department of Health, not New York State. You're responsible for environmental review, and Department of State is responsible for its permitting. They're two separate things. So the court said, you're making that argument now, but you didn't make that argument or make that clear in your determination for SEQR. So because you failed to make a reasoned elaboration on the changes in your determination not to do further SEQR review, your SEQR review is invalid. So the best practice here is just to be alert to proposed changes, go back and look at your underlying SEQR, and decide whether there was a change meriting further SEQR review or not. If there is, complete the additional SEQR review with, again, the keyword reasoned elaboration. Tell us why you're doing what you're doing, and you can move on. All right, one last case. I have 3 minutes.
Can we load Libby's presentation?
Sure, sure.
Oh, you're going to finish it off.
Yeah, this will just take a minute. This is the best one. Have you heard of this one? Has anyone heard of this? Okay, it's up closer to where I live. This is how we live. So this is about standing, and standing is when a party has a sufficient legal stake in a matter to permit participation in a lawsuit. So the facts are simple. A fire department holds the annual Squirrel Slam fundraiser. There's a squirrel hunting contest, and prizes are based on the weight of squirrels that you collect during this hunt. I did not participate. So the plaintiff sues. The fire department didn't conduct a SEQR analysis when they set this up and funded it and approved it. And they should have conducted a SEQR analysis. The interesting fact is the plaintiff lived 50 miles away. So the question is, does the plaintiff have standing here? The court tells us standing requires an environmental injury in fact that is different than the public at large. So the plaintiff argues that she is different than the public at large because she has a particular fondness for squirrels. The hunt had an impact on local ecology, and the contest may result in killing of squirrels that might have otherwise visited her property 50 miles away. I didn't know squirrels had such a range, but apparently they do. So the court tells us that because she lived 50 miles away and there is no evidence that the hunt impacts wildlife where she resides, and she didn't allege that she visited or used the area of the hunt, that she didn't have standing, and they didn't let the SEQR lawsuit move forward. But if she had alleged that, that area, say the area was a park or something, or some area that she went camping in or visited for whatever reason, then there's a good argument that she would have had some standing. So I thought that one was a fun one. Thanks, everybody.